Hello everyone. Welcome to today's webinar. I'm Ying Yu, General Manager of the Department of Chemistry, Bio and Pharmaceutical. Joining me today is my dear colleague, today's presenter, Ms. Li Zixuan. Zixuan is one of our senior associates and a highly experienced patent attorney. She has extensive expertise in patent prosecution, search and analysis, IP portfolio management, and strategic IP consulting, with a particular focus on technologies in biotechnology, pharmaceuticals, and medicine. Today, she'll walk us through some of the most recent developments in biopharma-related IP policies and practices, including patent linkage, post-filing data, and a draft regulation on data exclusivity, released by the NMPA this year, formerly known as the CFDA. She will also share with us several landmark cases along with key takeaways. Today, she'll walk us through some of the most recent developments in biopharma-related IP policies and practices, including patent linkage, post-filing data, and a draft regulation on data exclusivity, released by the NMPA this year, formerly known as the CFDA. She'll also share with us several landmark cases along with key takeaways, offering strategic insights and practical tactics. Now, I'll hand over to Ms. Li Zixuan. Zixuan, over to you.
Thank you, Ms. Yu. Thank you for your warm introduction. Hello, everyone. I'm Zixuan Li. Thank you for joining our webinar today. Today, I'd like to share you some recent updates on biopharma IP protection in China, with a focus on case studies and practical influences. As we know, the process of developing new drugs requires massive input, from drug discovery and preclinical studies to clinical research and final approval. Innovators face enormous financial and technical commitment. This process requires high investment, faces a long research and development period, and carries a high risk of failure. Given these challenges, a robust, effective, and comprehensive IP protection system is crucial to biopharma. In recent years, with a revision of the Chinese patent law and the other new regulations, China has established a complete biopharma IP protection framework to provide multi-tiered protection, covering the entire drug development lifecycle, which, for example, includes patent linkage system, special rules for supplementary experimental data, and drug regulatory data protection. So next, I will walk you through these three major aspects that reflect the latest changes in China's biopharma IP system and what they mean for innovator players. Firstly, let's begin with patent linkage. During the fourth revision of Chinese patent law in 2020, Article 76 was added to establish a patent linkage system. In 2021, China officially launched a series of legal and administrative measures. The measures for the implementation of early resolution mechanisms for drug patent disputes jointly issued by NMPA and CNIPA. The registration platform for marketed drug established by the CDE, administrative adjudication measures released by CNIPA, and related judicial interpretations released by Supreme Court. These regulations and rules collectively form the legal foundation of China's patent linkage system. China's patent linkage system mainly includes patent listing and disclosure, generics application and declaration, and the judicial and administrative dual-track system for drug patent disputes early resolution. Next, let me introduce the overview implementation of these three aspects. Regarding the patent listing, As of May 28, 2025, according to the data on the China Patent Information Registration Platform, this platform is just like the Orange Book in US. A total of 1,336 patent listings and disclosures were made, of which about 60% were chemical drugs, totaling 1,082. There were also 257 biological product patent listings and 397 traditional Chinese medicine patent listing information disclosures. Regarding generic drugs, as of May 28, 2025, according to the data on the Chinese Orange Book, there are a total of 16,528 generic drug patent declarations. We can see that the vast majority of them are chemical drugs, totaling 16,301 patent declarations. As mentioned earlier, China has established a distinctive dual-track system. That is to say, in addition to the court, MA holders can also resolve drug patent disputes in a shorter time at an early stage through administrative adjudications made by NMPA. According to a report issued by NMPA in 2024, as of September 13, 2023, NMPA received 149 requests for administrative adjudication, of which 128 have been concluded. We can see that there are quite a number of MA holders who chose to request NMPA to make rulings on drug patent disputes in the early stage, and NMPA exhibits a very high efficiency in ruling these cases. Obviously, the administrative adjudication system can help Biopharma save time in resolving disputes. Then, next, I will cite some cases in the dual-track system, some of which are from court decisions, and some are from NMPA rulings, and try to provide some strategic considerations for both innovators and generics. The first case is about palbociclib capsules, an anti-cancer drug held by Pfizer. First, let us sort out the patent linkage situation in timeline. The innovator submitted patent listing information of palbociclib capsules on June 30, 2021. Then, the generic manufacturer applied for the generic drug palbociclib tablets and made a Category 1 declaration, which means non-infringement declaration. Only 5 months later, the innovator submitted the patent listing of the tablet formulation. In this case, the innovator claimed that the above-mentioned Category 1, that means non-infringement declaration, submitted by the defendant was incorrect. Therefore, the plaintiff filed a lawsuit against the defendant's generic drug, palbociclib tablets, to determine whether it falls with the protection scope of patent listed to palbociclib capsules. However, the court held, in this case, palbociclib tablets and palbociclib capsules are different drugs with different pharmaceutical formulations. The patent in question in the case is palbociclib capsules, which is not a patent listed corresponding to the palbociclib tablets and does not belong to the palbociclib tablets relevant patents. So this case does not meet the acceptance conditions. From this case, we can see that the attitude of the court is clear, which means the linkage information of the capsule formulation cannot cover the protection of the tablet. Therefore, innovator should pay attention to the fact that different formulations of drugs should be listed separately in a timely manner. In this case, the time gap of less than 5 months brought different results. Here, perhaps some innovators would like to know, what about drugs with different strengths? Each strength should be listed separately, yes. But the court supported the reference relationship between different strengths. For example, if the innovator had listed the strengths of 25 mg of the tablet, the generic application for other strengths, such as 75 mg, constitutes infringement. Next, let's move on to the second case for innovator drugs. This case can help us understand the application of the rule of equivalent infringement and the rule of dedication in the patent linkage system. Firstly, let's sort out the situation of the patent in question. Prior to the lawsuit, the patent listed to the innovator drug underwent invalidation procedures. The original Claim 1 of the patent in question is about a formulation comprising multiple components, including antioxidants. The Claim 2 defined the antioxidant is selected from A, B, C, and D. During the invalidation trial stage, the patent owner revised the claims, further limiting antioxidant B to Claim 1, and deleted the original Claim 2. That is, after the invalidation trial, Claim 1 defines the antioxidant is B. However, in the generic drug preparation in this case, the antioxidant is A. The plaintiff innovator claims that the generic drug contains similar antioxidant A constitutes equivalent infringement. So, whether the generic drug does constitute equivalent infringement? The Supreme Court held the plaintiff made a clear choice of the specific technical solution by amending the claim, and selected the only antioxidant from the 4 parallel antioxidants recorded in the original dependent Claim 2, further indicating the intention of abandoning the technical solution of using A as a specific antioxidant. Therefore, the rule of estoppel applies to this case. The technical solution of using A and the antioxidant should not be included in the scope of equivalent protection of the patent in question. Accordingly, we would like to suggest to the innovator being cautious when amending claims. In conclusion, in the patent linkage system, the rule of equivalent infringement is applicable, but the rule of dedication and estoppel constitute limitations on the application of the rule of equivalence. Then, for generic drug, we take the same case as discussed in the last slide, which is about aldocacetyl soft capsules, for example. During the generic drug application, the defendant, generic applicant, only made a Category 4.2 declaration against dependent Claim 2 of the patent listed, and did not make declarations against other claims. For example, independent Claim 1 and Claims 3 to 7. The Supreme Court held, in order to ensure the accuracy of the patent declaration, the generic applicant should, in principle, make a declaration against the broadest claim in the patent listed. It can be seen that the generic applicant should make a declaration against the broadest claim, for example, the independent claim of the patent listed. Okay, now let's review and summarize the considerations mentioned in the previous cases. For innovator drug, we here provide the tips that different formulations of drugs should be listed separately and in a timely manner. Additionally, the rules of dedication and estoppel constitute limitations on the application of the rule of equivalence. For generic drug, generic applicant should make a declaration against the broadest claim of the patent listed. Furthermore, here we also wanted to provide some general tips for both innovator and generic manufacturer. Due to the limit of time, I will only briefly mention them. The first is the administrative adjudication procedure runs parallel to the corresponding patent invalidation procedure. Thus, filing a request for invalidation of the patent listed does not necessarily affect the process and the result of the administrative ruling. Second, patent wherein the substantial improvement is the crystal form of a compound, but the use of the compound is known, belong to patents that cannot be listed. Okay, let's move on to the second part, supplementary experimental data. The acceptability of supplementary data, or called post-filing data, attracted much attention in the art of drug patents. Currently, in China, submitting post-filing data is feasible. The issue that applicants would pay attention to is, where is the boundary for accepting supplementary experimental data? Now, let's try to discuss this question using a positive case and a negative case. The first positive case is a patent re-examination case of a PDE5 inhibitor. In this case, the purpose of the applicant submitting post-filing data is to prove that the claimed composition has good temperature stability. In this case, the examiner and the re-examination panel gave different opinions on the acceptability of the supplementary data. During the substantive examination stage, the examiner refused to accept the data, but in the re-examination procedure, the panel finally accepted the supplementary data. Now let's take a detailed look at this interesting reversal. Regarding this supplementary data, the examiner rejected and contended that the technical effect recorded in the description is only an assertion and has not been verified. The supplementary experimental data cannot prove that the applicant has confirmed the above effect before the application date and cannot be used to prove the inventiveness of this application. However, the re-examination panel held that the description clearly records using stabilizing polymers A, B, and C to stabilize the composition. Moreover, examples 1 to 3 provide specific preparation examples of the composition comprising the stabilizing polymers A, B, and C. Based on the descriptions, a person skilled in the art can confirm the applicant has clearly paid attention to said technical effects, and the composition has been completed before the application date. Therefore, the panel held that the supplementary data is acceptable. Accordingly, the key for the acceptability of post-filing data is the technical effects demonstrated by the post-filing data should be what a person skilled in the art can obtain from the contents disclosed in the original patent application. Next, let's study a negative case together to further understand the boundary. Let's take empagliflozin patent invalidation case as an example. Empagliflozin is a well-known anti-diabetic drug and belongs to SGLT2 inhibitors. The compound patent of this drug mainly involves the generic Formula 1. The description records 57 specific compounds falling within the general Formula 1 and discloses their preparation methods. The specific compound empagliflozin contained in the marketed drug, as shown in the figure below, numbered as compound 3 in the patent in question. In order to respond to the invalidation challenge, the patent owner filed post-filing data to try to prove that empagliflozin has good selectivity on SGLT2 than SGLT1. Specifically, the supplementary data proves that empagliflozin has weaker inhibition on SGLT1, thereby providing stronger inhibition on SGLT2. However, the original description only discloses the preparation example of these optional compounds, but does not provide any specific data in the SGLT2 or SGLT1 inhibition activity assay, let alone any specific data of the compound in the SGLT2 than SGLT1 selectively assay. Therefore, the panel held that, according to the content of the application documents, the technical information that a person skilled in the art can obtain is that the compounds of Formula 1 have SGLT2 inhibition activity, but it is impossible to conclude that the empagliflozin compound is a preferred compound with high selectivity of SGLT2 than SGLT1. The supplementary experimental data in this case belong to additional selection of preferred compounds and screening of preferred activities, which should be clearly excluded. Therefore, it is clear that supplementary data related to additional selection of preferred compounds is unacceptable. Okay, here we have arrived at the last part, drug regulatory data protection. In addition to patent protection, drug regulatory data protection, or called RDP protection, provides another regulatory buffer to protect true data. China has also proposed its RDP system on March 19, 2025. China's NMPA released the implementation measures for drug regulatory data protection and the corresponding working procedures, the draft for public review. These two draft documents indicate that the scope of RDP includes undisclosed, independently generated clinical trial and other trial data filed in support of a MA application. Once adopted, such proposed RDP will provide data protection starting from the data of obtaining MA in China. This table shows the proposed data protection period for specific categories. The proposed RDP provides data protection for innovator drugs, improved new drugs, and first-to-market generic drugs. Specifically, innovator drugs could obtain up to 6 years exclusivity protection after obtaining MA in China. And the improved new drugs and first generic drug could obtain up to 3 years protection period. The data protection period of category 5.1 drug needs some calculation. Taking important innovator drugs that marketed overseas as an example, once adopted, China RDP period would be calculated by subtracting the time gap between the China marketing application date and overseas marketing date from 6 years. Similarly, for imported improved new drugs marketed overseas, the RDP period would be calculated by subtracting the time gap between the China marketing application date and the overseas marketing date from 3 years. It can be seen that if the draft measures are adopted for global innovators, starting the marketing application in China as early as possible could maximize the RDP period and create advantage for the important drugs in China. Once adopted, these measures will provide enhanced regulatory data protection for biopharma companies. Okay, to conclude, patent linkage, special rules for supplementary experimental data, and drug regulatory data protection collectively forge a robust shield that safeguards the interests of biopharma companies. China's biopharma IP protection framework is becoming more comprehensive and mature, creating a more supportive environment for innovation. Thank you for your attention. If you have other questions, please feel free to contact us.
Okay, it's about the time here today. Thank you very much for your interest and participation. We as BTL is devoted to bring you the latest news, events, and trends of IP practice in China. Hope to see you next time. Bye-bye. Have a nice day or a nice dream.